Hello and welcome to Friday Live. I'm your host, Strata lawyer, Amanda Farmer. We are here every couple of weeks on a Friday live on the Your Strata Property Facebook page. We go live out to LinkedIn and to YouTube as well. I am so looking forward to being here with you this Friday, catching up on all things Strata. I've pulled out a few hot issues that have crossed my desk, that have been on my desk, that are still on my desk to share with you that might answer some of your Strata questions, might assist you wherever you're at in Strata today, whether you're a manager, a committee member, an owner, a resident, an investor, a tenant, a Strata lover, Strata lawyer. You are all more than welcome here today. If you're rolling in live, I love to see your hellos in the comments, whether you're commenting on LinkedIn or YouTube or Facebook. I should be able to see them here at my end. Love to know maybe where you are today, what you are up to. Do go ahead and share. I have had a fair bit of client work to be getting through this week and a lot of tribunal matters. Some of you would have heard me say that before. Lots of work happening in the tribunal for Strata lawyers at the moment, and Strata managers are feeling this as well. And those are the couple of points, issues, topics I have on our agenda for today. They relate to tribunal proceedings, costs in tribunal proceedings, and what happens if you are a successful owner, if you have successfully won a case against your owner's corporation. What are the cost consequences of that? That is an issue that I've been turning my mind to for a couple of clients in my legal practice this week, and thought I might share my thoughts on that one here with you. And I've also got a case, a recent decision from our New South Wales Tribunal that came down, I think it was in December last year. I saw it at the time. I thought, oh, that's a great one for Friday Live. I'm going to put that one on my list. I love to pull out these cases that teach us a few different lessons about Strata all in the one case is always fun. So I'm going to share that one with you as well. But some exciting news that I saw in my social media feeds just this morning is that the Archibald Prize is coming to the little New South Wales Central West town of Mudgee. And many of you will know that for many years I have lived in Mudgee with my family. We moved back just a month or so ago for our son to start high school here in Sydney. But I'm heading back to Mudgee in just about 5 weeks, I think we are, 5 weeks' time, to host our annual one-day CPD event for our New South Wales Strata managers. And oh, what timing! They must have known that I was hosting an event for the City Slickers, who I know are going to love this. The Archibald Prize is visiting Mudgee for the first time. So this news just out today. Australia's most recognisable portrait prize, the Archibald Prize 2025, will be touring to Mudgee for the first time. Mudgee Arts Precinct is hosting the prize from the 20th of March to the 3rd of May. So I immediately jumped into our VIP Facebook group for those who are attending our CPD day. We love an acronym in Strata. They just keep coming. And let them know, hey, put this on your itinerary, put this on the agenda for maybe Saturday morning after our CPD day, which is happening on Friday, the 19th of March. On the Saturday, head over to the Art Gallery, very close to my home in Mudgee. Head over to the Art Gallery and check out those artworks, those amazing artworks from the Archibald Prize 2025. Very exciting for little town of Mudgee. So if you've already got your ticket, I know many of you who tune in here do have your ticket to our one-day CPD event in Mudgee. Make sure, pop that trip to the Art Gallery. They're in the agenda for the family. We've only got a few tickets left. We are over now, 75% sold for our CPD event in Mudgee. If you are a New South Wales Strata manager, need to grab some CPD points, want to find out what this event is all about, the place to go is yourstrataproperty.com.au/CPD event. We've got that link for you coming into the comments here. Snap up your seat. This one usually does sell out. If you are a pro member inside our online community, there's a huge discount there for you on tickets. If you are a member, discount there for you as well. Nobody should be paying full price. You get a great deal on those tickets if you join up for membership. Encourage our Strata managers, if you're serving schemes in New South Wales, we've had Strata managers from Victoria attend previously who are serving schemes in Victoria as well as New South Wales. Come to Mudgee and enjoy this beautiful part of the world. Come on and join us before those tickets run out. All right, so that's what I wanted to say about the Archibald Prize and Mudgee and our CPD day. Getting a few hellos here in the comments. Lots of you here live. Hey, Leonie. Hey, David. Good afternoon to you. Shana's telling me just compiling answers and information for our Strata lawyer to finally get our application in to NCAT. Awesome. Very exciting. Congrats. Very exciting to be at that stage. Shana, I know that this is something that you've been working on for some time, and great that you got the support of a Strata lawyer there. Let us know how you go. Gabina, nice to see you too. Petra is here as well. Kareem is saying happy Friday. Great to see you again. Good to have you here, Kareem. Hey, Nathan. Hi, Amanda and Strata family. Hunter Strata all here. Now, I always have this image. I know you guys have told me this a couple of times. Hunter Strata just goes, it's Friday, down tools, 4 o'clock, we're in the boardroom. I mean, like, is it drinks? Is it coffee time? Is it notepads? Is this an educational session? Let me know, Hunter Strata. I want a photo. Can we do a little selfie in the boardroom and send it through and let me know if I have your permission. I can share that and encourage our other Strata managers to do the same. Tune on in on Friday, knock off early and learn. Nathan's letting me know they've got a few hard solos with them. Okay, excellent. Just a few. David saying, might say hello at the ACSL conference. Awesome. So that's the Australian College of Strata Lawyers, ACSL. You telling me, David, you're joining us at the conference? That would be so great. Welcome. I'll come back around and share a link to that conference for anyone else who's interested. That is in Melbourne in March. It is the week before our Mudgee event, so busy times here for us. I do sit on the conference committee. I actually chair the conference committee of the Australian College of Strata Lawyers. We've got an awesome program for the conference. So yeah, I'll share the details of that one. If anyone else, owners are welcome, Strata managers, absolutely. We've got some Victorian Strata managers attending, committee members. You're welcome at the ACSL conference. And if you're attending, if you are attending and you are often tuning in here on Friday Live, come and say hello and introduce yourself to me, as I know David will. Awesome. Hey, Sean, John, great. Excellent. All right. So where are we starting today? I think we're starting with costs. We're starting with costs. And I have been working on a case this week where this issue has come up, not in at all a controversial way, because it's not my first rodeo, been here before. The dispute in the tribunal was settled and the result was in my client's favor. The usual, I'm sorry to say, work order, got to get work done around the building on the common property that is impacting my client's lot, damages to be paid to my client for lost rent, and costs as well. And when you are acting for an owner or owners, absolutely, this is why I'm sharing this, when you are representing yourself in tribunal proceedings and you're about to get what you want, or some of what you want, or enough of what you want to feel that you can resolve the dispute, you can settle with your owner's corporation, it's important to turn your mind to costs. What happens with costs? If you have had a lawyer representing you or you've sought legal advice during the proceedings, you might have some costs that you wish to seek from the owner's corporation. If you're settling a case, you can ask if the owner's corporation will make a contribution to your costs. They might say yes, they might say no. If you're before the tribunal and you have been successful, the tribunal will, if you ask, give you an opportunity to make submissions explaining why you might want your costs awarded. If you have not incurred any costs, if you haven't engaged a lawyer, if you haven't sought legal advice, you haven't paid experts and got expert reports, you may not have any costs. Having said that, and indulge me on this little tangent for a bit. Having said that, it was only, I think, yesterday, I saw a colleague on LinkedIn, lawyer, Western Australian lawyer, I think, talking about a case coming out of the State Administrative Tribunal in Western Australia, SAT. And in that case, I think it might have been a December decision. Might put that on my list to share in a future Friday Live. In that case, I think it was the Strata manager, if not a property manager, represented themselves in a case, I believe, and was awarded their time, an hourly rate, essentially, for their time spent on the case. And I haven't read the case, I only read the summary, but there was this question about, okay, so your time, there is a value on your time and your time lost prepping the case, being at the hearing, you may be compensated for that. And my take on that was, okay, that's a little bit unusual. That's generally not, in my experience, how it works for self-represented litigants. I don't know if it was because this person had particular expertise as a manager or a property manager or what the story was, but I just wanted to give you that little caveat on what I'm sharing with you at the moment, that, if you self-represent, if you don't have legal costs, expert costs, then you probably don't have costs to claim. Maybe that's shifting, maybe that's changing. That Western Australian case might be a good one to have a look at, for us all to have a look at, and have a closer look at what it might take for a tribunal, wherever you are, to make that decision to award you some costs of your time, some compensation for your time lost. Interesting one to have a look at. So that's not what I want to talk about today, but we will flag that one and see if we can come back to it. The Owners Corporation, where you are involved in proceedings suing your Owners Corporation, you're a lot owner bringing proceedings against your Owners Corporation, it's not unusual for the Owners Corporation to have a lawyer and to have been incurring costs, briefing that lawyer appearing at the hearing. And it's a common complaint. I talk about this in my education that I deliver for all about the tribunal and how to run your tribunal case. You often tell me that's unfair. It's unfair that the Owners Corporation, they can afford a lawyer. They're allowed to have a lawyer. And because I am a member of the Owners Corporation, I am contributing to the costs of that lawyer. The lawyer's being paid from a fund, from the account to which I have contributed. I pay my levies. Sometimes there might even be a special levy to pay for legal fees during the course of proceedings. And I get asked by owners, well, I'm the applicant or I'm the other side in these proceedings. Do I have to pay this levy and contribute to the costs of the case that is being run against me, or the costs of the respondent responding to my case? That doesn't seem fair. And the short answer to that is yes. While those proceedings are ongoing, and until we know who wins, the lot owner is contributing to the costs of the case that is being run against them. They have to continue to pay their levies. And it is only at the end of the case where, if they are successful, they may have, well, if they are successful, they will have their share of those costs, should have their share of those costs reimbursed to them. And let me explain to you how I know that, where I'm getting that from. It's not just a cool deal that a lawyer might strike for their clients, as I like to do for my clients. It's actually in the legislation that where an owner's corporation is unsuccessful in proceedings brought by a lot owner, it cannot take any of its costs or expenses from contributions to which the lot owner, the successful lot owner, has contributed. That was my top of the head summary. I'm actually going to take you over now to the section and see what the words actually say. I will just share Yeah, I'll share what I've got here for you. All right, so the section I'm talking about in the New South Wales legislation is section 104. Similar to words to what I've just said there. An owner's corporation cannot, in respect of its costs and expenses in proceedings brought by or against it for an order by the tribunal, levy a contribution on another party who is successful in the proceedings. Uh, if the owner's corporation is unsuccessful, it can't pay any part of its costs from its admin fund or capital works fund, but may make a levy for the purpose. Um, that this is not a very practical section. You might be coming to that conclusion, saying, "Well, hang on a sec. We don't know if we're going to be successful or not. We're an owners corporation. We don't know if we're going to be successful or not. We've got to pay the lawyers as the bills are coming in. Are you telling us we have to immediately strike a special levy? How does this work in practice?" And the way that we do it and try to massage this section a little bit is that, as I've said, the lot owner continues to pay their levies and contribute to the costs of the owners corporation in the proceedings. And then if and when the lot owner is successful in defending the owners corporation's claim against them or successful in their own claim against the owners corporation, they then work out, or together with the owners corporation, they work out how much money did the owners corporation actually spend on the case, and then work out what is your unit entitlement share of that amount. Okay. I just had the urge to give you an example and do some maths here live right in front of you. But no, I have an advisor's voice in my head, very smart person saying, "Amanda, do not do maths on stage." So that's not going to happen. But where you know how much the owner's corporation has spent on legal fees, you can work out what that lot owner's proportionate share based on unit entitlement has been. And then that money needs to come back to the owner, because the lot owner should not be contributing to the costs of the case where they have been successful. Just checking that I'm with you. I think I've just frozen there. Back now. So this task can be, of working out what the successful lot owner's share of the cost has been, can be a little tricky where the owner doesn't trust the owner's corporation and doesn't trust that the amount that the owner's corporation is telling them has been spent on legal fees is actually the correct amount. So the owner's corporation might say, "Yeah, we spent 50 grand on legal fees. So, we'll give you back your unit entitlement share of that." Owner says, "Oh, hang on a sec. You had two lawyers, you had a senior counsel, the hearing ran for 2 days. I don't think you spent 50 grand on legal fees. I think you spent about 3 times that." And when my clients are skeptical like that, and when we think that the numbers don't quite add up, what we ask for is the source documents. And what are the source documents? The invoices that the lawyers have sent to the owners corporation throughout the course of the proceedings, so we can do the calculation and work out exactly how much has this owners corporation spent on the legal proceedings, and ensure that we're comfortable that the proportionate share that we're asking for or that's being offered to the owner to be returned to them, be credited to them, to be paid to them, whatever the deal is that's going to be done, that is the correct amount. So often the only way to know that is to get the copies of the invoices that the lawyers have sent. And sometimes there is privileged, solicitor-client privileged information in lawyers' invoices, especially if they are lawyers that produce very itemized invoices. So it might be necessary to pull those itemized pages out of the invoice, but we usually, as lawyers, will send invoices with a cover page that will have the matter details, the date, the period of time that the invoice covers, and the amount of the legal costs, ex GST plus GST, any disbursements that are in there. So there'll be a summary page. And in my experience, when I've acted for owners who are trying to work out, what has been my contribution to the owners corporation's costs, and we have asked for copies of invoices, then it's been very easy for the owners corporation or the lawyers to produce those summary pages from the invoices, and we can go through them and add all of that up. The other place that you want to look is in the financial statements for the owner's corporation, and there'll be a line item for legal fees. The only trouble with that is you don't really know the period necessarily that it covers, unless you're looking at every month's financial statement. So it is usually more accurate to have a look at the invoices themselves. Heading over to those comments, I think we've got a couple of comments on point here. Leonie saying, my ex-strata manager was awarded costs against me representing our owner's corporation for his time, now currently living in Vietnam. Okay, hopefully not on the proceeds of that litigation, Leonie. So yes, so Kareem's also asking about the costs of strata managers who have deep knowledge of the legislation defending an OC be considered for cost recovery. I've been told not. Yeah, so this is why, Kareem, they're not legal costs. They're not legal costs. This is why I also am of the view that this decision I was reading about in Western Australia was a bit unusual, and my ears pricked up, and I was like, oh, okay, there's another ground there on which to claim costs, because I wasn't sure that, I didn't think that the strata manager representing the owner's corporation then had a claim to legal costs. Happy to hear about a case that says otherwise. I've already mentioned that Western Australian case that popped into my LinkedIn feed this week. So Philip saying, not just lawyer fees, strata manager and consultants. Yes, so that's a really good point. I'm going to go back to section 104. So what Philip's talking about now is an owner who is successful in proceedings, the owner's corporation cannot recover any of their costs and expenses from the owner. And this is there's a fine point here. I'll just add this section back to the screen. You'll see here that this section doesn't say legal costs. Okay, it says its costs and expenses. The owner's corporation cannot in respect of its costs and expenses. So I think this section 104 is a bit broader than if you were seeking a cost order in your favor, which is, in my general experience, legal costs and expenses. But in section 104, I think the claim is broader. And yes, if there have been fees charged by the strata manager to the owner's corporation for the strata manager's time dealing with the litigation, I think a successful owner should not have to contribute to those. So I think section 104 is broader than that cost order provision, which is otherwise in the Civil and Administrative Tribunal Act. Thanks for pointing that out, Philip. I think that is correct. Just bringing that one back. Sean is saying, it depends how the charges are itemized into strata plan accounts. Yeah. And you know what, Sean? That's to my point about, can we just look at the financial statements and check that line item and see, okay, 50 grand spent on legal costs. We know there was no other legal case happening. We think that's our amount that we have contributed to. I've been in cases where buildings have been maybe a little bit, I'm going to say the word embarrassed, maybe a bit wanting to keep that number under wraps. We don't want the owners knowing that we've spent $500,000 on lawyers. So the numbers end up being put in different and sometimes weird places. So there's $100,000 in the line item for legal costs, and then there's $200,000 in the line item for consultants. And then if you actually do a search and you look at all the invoices, and then you think, hang on, these are all lawyers' invoices. That should have been coded under legal costs. Why wasn't it? I'm thinking of a big case in particular that I was involved in, and there was a huge number under consultants. And when we asked about it and looked into it, it was mostly legal costs. And this was a committee that was saying to its owners, we got a good case, we're going to defend this. These applicants don't know what they're talking about, that we're following the legal advice. And the applicant owners were saying, you're spending hundreds of thousands of dollars of owners' money, and owners just couldn't see where that was recorded because it was recorded under consultants' fees, and no one looked very hard at that. So little tip there for inexperienced players, if you're trying to track down the legal fees, look under the consultants line item. That might help you. Bev saying, I'm self-representing as an owner against the OC. They have a lawyer representation. As an owner, we have not been advised of a letter of engagement or costs so far. Should they have advised the owners of the costs incurred? Yeah, so Bev, They absolutely should have advised owners of the engagement of the lawyer. And just because it's helpful, I've got that section. Here's the section I prepared earlier for you. Section 105 in the New South Wales legislation is the section that requires a lawyer's cost agreement when issued to an owner's corporation to be given to each owner and strata committee member not later than 14 days after the disclosure is made. So you get a cost agreement, strata managers, 14 days. That's got to be circulated to all owners. Give a copy to all owners. In my experience, this doesn't happen as often as it should. But Bev, that's the answer to your question. Yes, you should have got a copy of the lawyer's cost agreement. Lawyers legally must be issuing these cost agreements, so I'm sure that it exists. But you are not otherwise entitled to receive copies of invoices, for example. So it's not unusual that the committee, you wouldn't know how much is being spent on lawyers until you check those quarterly financial statements, or you see the financial statements at the AGM, or you do a records inspection and you see the invoices and you see the financial statements. So you've asked there, should they advise the owners of the costs incurred? No obligation to proactively advise you of the costs incurred, but yes, a proactive obligation to provide you with the cost agreement, which has the estimate of costs, the costs that are estimated. Ready Strata Management, hello there, saying typically the strata manager should be itemizing any additional service fees for administration or representation of the owner's corporation in any tribunal matter. It provides transparency for the OC when reviewing the financial statements. Yep, and it's very helpful for that Section 104 task of recovering the owner's contribution, the successful owner's contribution to costs and expenses of the litigation. All right, that is what I want to say, probably a little more than I had planned, what I want to say about Section 104 and that cost recovery. Some good questions there about strata managers and cost recovery where the strata manager is running the case. I'm going to make a note to return to that Western Australian case that I stumbled across this week. Thank you to, I'm sorry, I can't remember the name of the colleague who posted it. Somebody posted it. I think it was a lawyer from Bugden Allen Legal in Western Australia. I could give you that much credit. Apologies for not recalling that name, but I'll read that case and also have a look if we've got any similar New South Wales cases about recovery of costs that are not otherwise legal costs. Okay, seems we've got a little bit of interest here in that topic. Good to know. All right, so here, next up, I have a case for you involving a lot owner who sadly was not successful in their application. And I'm back. And I say sadly because I think they could have been. And I think, as I hinted at in my invitation email today, inviting you to attend today's chat, where they fell down was their lack of evidence, not having the right evidence to prove their case at the hearing. And those of you who've been following me for a while, tuning into this education, you would have heard me say this before, before you start tribunal proceedings, you got to have your ducks in a row. Litigation, when you're before the tribunal or you're in a court, that is not the time to build the plane while it's flying. Sometimes in life we do that, but when you are in legal proceedings, they matter. And you really want to be very clear about how you're going to prove your case before you file it, right? So this case has some good lessons from a number of different perspectives and a number of different lessons. But the big takeaway that I wanted to share with you today was about making sure you have evidence, including expert evidence when you need to prove a particular point before the tribunal. The case is MacArthur and the owners of Strata Plan 30924. It was heard in August last year. The decision came down in December. Both parties were represented, applicant represented, respondent owners corporation represented. I have before you here a highlighted copy of the decision, which I'm going to walk through and focus on those highlights. As always, we save the highlighted copy of the decision into our member forum for any members who want to download that highlighted PDF for future reference. But otherwise, this is a published case. It is a reported case. So we have a link for you, I think, to the Case Law New South Wales version of this case. So these were proceedings where the applicant, lot owner, claimed that the owner's corporation improperly gained access to his lot, first thing, to carry out a repair to common property in the shower recess. And as they were doing that repair, the complaint was that the owner's corporation damaged lot property. The claim from the owner was that they had suffered $47,000 in damages because of this damage to the bathroom, essentially. So the applicant sought orders that the owner's corporation fix the bathroom floor by replacing the remaining brown tiles for the white tiles used by it in the remediation of the shower. So immediately tipped off here, this is an argument about mismatched tiles. I get asked this question a lot with bathroom remediation and disputes about bathrooms being fixed in buildings. What obligation does an owner's corporation have to make sure the tiles match? That question came up here in this case. The applicant was also seeking their damages, that $47,000, and costs. What were the facts or the relevant facts of the case? Well, first up, the tribunal says here, and I've highlighted all of this because it's helpful, the tribunal preferred the evidence of a Mr. Peterson. Now, granted, I've read this a couple of times quickly. I'm not quite sure who Mr. Peterson is, but I think Mr. Peterson might be the strata manager. I think from what Mr. Peterson was doing for the owners corporation, I think Mr. Peterson is the strata manager. I accept the evidence of Mr. Peterson as to the sequence of events, which are material to the issues in these proceedings. The reason why I prefer Mr. Peterson's evidence is that he was directly involved in the events as they occurred. He was required for cross-examination at the hearing, but he was not available. It was ascertained at the hearing that the respondent, the owners corporation, was not ever put on notice that Mr. Peterson was required for cross-examination. So stop there. Really important point. If you want to cross-examine the other party's witnesses at a hearing, you need to tell the other party it well in advance. Sometimes there are directions made by the tribunal giving you a date by which you must inform the other party of who you want for cross-examination, but that doesn't always happen. And so it can get forgotten. Ask me how I know. But it's important to put the other side on notice. We require Mr. Peterson for cross-examination at the hearing as early as possible. So Mr. Peterson doesn't turn around and say, oh, sorry, I'm on a flight to Bali. I can't make it. Don't miss that step, because that step was missed here. And we don't really know if it would have gone differently if Mr. Peterson was available for cross-examination and the applicant could have got some helpful evidence out of him. But in any event, the tribunal has said, I find Mr. Peterson's evidence should not be given any less weight because he was not available. The reason for this is that most of what he states is verified by contemporary documents annexed to his affidavit. So I imagine Mr. Peterson's affidavit was very much like I see many strata managers' affidavits, just relaying, this is what's in my file. This is the email that was sent on this date. This is the work order that was sent on this date. This is the expert report that was obtained on this date, and just attaching those documents. If that's the kind of affidavit that's being given, the tribunal is going to be pretty satisfied that that is true and correct. What is in that affidavit is true and correct because it has the documents before it. So tribunal was not too worried that Mr. Peterson wasn't there. And to the extent that it was a problem, it sounds like that was the fault of the applicant because they didn't ask for Mr. Peterson until on the day of the hearing. So what happened in this case was March 2024 when Mr. Peterson got an email from the occupiers in lot 27 reporting urgent water leakage coming from above, from lot 29 above. And they said, this has been continuously happening for the past 3 days. There were photos attached. It's water leakage down the wall in my bathroom. I've spoken to the tenant, and the tenant said something about waterproofing to the real estate agent, but nothing's happening. There appears to be broken and depressed tiles in Unit 29, which would jeopardize the waterproofing. Not sure how that person knows that, but I suspect the tenant upstairs told them about it. So Mr. Peterson communicates with the property manager of Unit 29 to work out what's going on. The property manager says it appears that the water might be leaking from the edges of the tiles, might be an issue with the shower tray, and it needs better waterproofing. And Mr. Peterson informed the property manager that he'd organised a plumber to investigate. But if it was a private matter, said Mr. Peterson, he would add the cost to the owner's levy ledger. Tribunal doesn't say anything about that. That's not an issue in these proceedings. It's not something the tribunal's been asked to make a determination about. It didn't happen anyway. Turns out this is an owner's corporation, common property problem. But I highlighted that because I thought, oh, there's a real insight there into how strata managers think. And if it's a private matter, I'll just add the cost to your levy ledger. That's not allowed. That's not allowed. Don't do that, strata managers, okay? Maybe there's a bylaw in place in this building that allows for certain expenses to be added to ledgers. You'd have to have a very close look at that bylaw to just check that it was valid, because we've had a number of tribunal decisions invalidating those kinds of bylaws, but a dangerous move to make, I think, regardless whether there's a bylaw or not. If there's no bylaw, absolutely no, we don't add these things to owners' ledgers. Okay. Thought that one was worth pointing out. By April, the applicant, who is the lot owner, has written to Mr. Peterson saying that the repairs that were conducted, so repairs organised, shower tray repaired, owner says that these repairs didn't meet satisfactory standards. The applicant said the tiles don't match. So it sounds like the shower tray and its tiling was ripped out, new waterproofing membrane. And I know, because you tell me all the time, and I see it too, the rule of thumb is, and we only tile up to 2 rows of tiles. And if you want more tiles, that's lot owner responsibility. And if you, and otherwise the owner's corporation is going to pay for 2 rows of tiles. So it sounds like that general rule of thumb was applied here. And that's what happened. Tiles did not match, resulting in a job that looks out of place due to obvious differences in tiles, poor tiling workmanship, including uneven tiling and uneven tile gaps. The section replaced did not span the entire shower floor, it being apparent that the contractor did this to avoid moving the shower screens and brackets. There was a cracked tile that was not earlier cracked, failure to remove all tiles and re-waterproof the entire floor in this 5 square meter bathroom, no overlapping the waterproofing from existing to new, posing further potential issues. So the applicant's written all that to the strata manager, requested a complete re-waterproofing of the entire bathroom floor, replacement of the floor tiles, blah, blah, blah. Bear in mind here, no reference here to any expert report. Just the applicant writing to the strata manager saying, didn't do a good job. Not in, I think the words were, does not meet satisfactory standards. I don't know what standards the owner might be talking about. Not referring to any expert advice that they might have got about this. I mean, it sounds like that's not a very nice way for your bathroom to end up. If you've got cracked tiles and they didn't even move the shower screen and it looks like they've done half a job of the wall tiling, yeah, I'd be pretty annoyed too. But I don't know, because I'm not an expert, whether the work has been done according to standards or not. The applicant requests complete re-waterproofing. The respondent attempted to address the applicant's concerns. They do a couple of things. They, I think, remove the, yes, there it is highlighted there, remove the old shower screen, extend the size of the shower to square off, installing a new shower hob, I think that's supposed to be, installing new floor tiles that closely match the existing ones with prior agreement from the applicant. So they've got some new floor tiles there. Okay, so the applicant files an affidavit, and the tribunal says on occasion the applicant's evidence departs from factual matters and goes into evidence which I find he does not have the expertise to give, such as stating that the contractors broke the seal on the original waterproofing and the copper pipes are likely the cause of water ingress. I will not give weight, says the tribunal, to the applicant's evidence when it appears to me that he is giving evidence that goes to waterproofing or plumbing issues. That's because the applicant has not demonstrated that he has training, expertise, or experience in these areas. Okay, key point. It might be the case that the work that's been done, you know, because you've been involved in other strata buildings or you've done other work in other properties, you know, hang on, that doesn't look like the right way to do things. Surely there has to be a whole new waterproof membrane. Surely all the tiles have to come out. You are not necessarily, unless you are a waterproofing expert or a builder, remedial engineer, unless you personally have these qualifications, you are not able to give that opinion Experts can give opinions to the tribunal. Lay people cannot. Lay people should not be giving opinions. Lay people rely on the evidence that they're giving about facts that they're aware of, but they cannot give expert evidence or expert opinion. They just don't have the qualifications. And this is where I've said, I feel a bit sorry for this owner, because I think this is a dodgy job on the part of the owners corporation. I think some of you think that as well. I think some of you have been here. And I have seen cases won by owners in this exact same circumstance, with whole bathrooms having to be remediated, with damages paid. I talk about a case run by a real estate agent who is a member inside our online community, successfully run by him, a case that I share on our Strategic Strata Litigator webinar. This is exactly his fact scenario, but because he had expert evidence, he was clever enough to advise his client to get expert evidence. The tribunal was able to look at that and say, yeah, I rely on the evidence of the expert. This hasn't been done in accordance with the law, and it's all got to come out, and it has to be done properly. And he won that case. That's what you need to do. That's what you need to do in these cases. Okay, so the applicant was saying, I observed they removed part of the tiles in the shower recess on the floor, including one row, he only got one row, not two, of tiles up the wall of the shower, and then replaced them with new white square tiles, which were not like for like, and in fact do not match the existing floor tiles at all. The applicant, so that's a complaint about the mismatched tiles. The applicant states that when they did the work, the contractors cracked a tile located between the shower screen and the bath. He says that the crack was not there previously, and despite it only being small, water can enter this area, causing further damage. How do you know that? How do you know that? You might say it's common sense. I don't know that. I don't know that water can get through a cracked tile and cause water damage. Can it? I don't know. I'm going to be asking a remedial engineer. I'm not going to be saying that to the tribunal. And the tribunal says, I do not accept the applicant's evidence regarding water entering the area causing further damage. I find that is a question of fact, whether water has in fact entered through the crack. I accept the applicant's evidence as to the existence of the cracked tile. So yes, we can see there's a photo, there's a cracked tile. We don't have to go out getting expert reports confirming that there's cracked tiles. But whether the water has actually gone through, that has to be proven. So there needs to be tests done to prove that the water has gone through. And then what I've just said is, and is it causing damage? Who knows? Who knows? The applicant said there's now mold in the lot, and in particular the bathroom, because of this dodgy work. Okay, there might have been some evidence of that. There's a quote for restorations to clean the mold, $6,000. The tenants broke their lease in October due to ongoing inspections and maintenance. Applicant said he couldn't rent the place again until December. Then he had to advertise it at reduced rent. So he's lost some money there, $8,000 lost rent that he's claiming as part of his damages. And he's worked out that the cost to remediate the bathroom is between $12,000 and $24,000. Could be 12, could be double. Sounds like they're quotes that he received to completely remediate the bathroom. What is missing here is any expert opinion, any expert evidence, any report saying the bathroom needs to be remediated, saying that anything further than what the owners corporation has already done needs to be done. Big missing piece. All right, so the decision then goes into this question about whether the strata manager could have gained emergency access to the lot. Remember, the tenant below in 27 said, it's been leaking for 3 days. There's water coming down my wall. Strata manager got a plumber in there immediately, didn't seek consent. So exercise that right under section 122, subsection 3. There it is there. I haven't highlighted it, but it's there. Get my mouse in the right spot. The owners corporation in an emergency may enter the lot at any time. I'm not going to go into too much detail about this, but the tribunal ultimately finds, there was an emergency. Strata manager acted appropriately. This was the kind of emergency situation that the section calls for. So no issue. Tribunal found no issue with that access to the lot without consent. If you're ever running a case about that, or having a case run against you about that, this is a good case to look at, because you can see there's a few paragraphs there about that issue of emergency access. Not going to get into those details right now. Instead, having a look at whether or not the owners corporation has damaged the lot property. The tribunal had a look at that question. While they were doing the work, did they cause damage to the lot property, and are they liable for that damage? Because section 122 subsection 6 says that the owners corporation will be liable for any damage to a lot or its contents if it's carrying out work under its powers of access, under its section 122 powers of access. So what was the damage we're talking about? Applicant said the mismatched tiles is damage to the lot. The cracked tiles near the bath is damage to the lot, and the mold is damage to the lot. And all of that is the owner's corporation's fault, says the applicant. As a result of the work carried out by the owner's corporation in his bathroom, he says he's got a bathroom that's mismatched so far as the tiles are concerned, and as a result, diminishes the value of the lot. Probably right. That's probably right. But here's the problem. There is no evidence before the tribunal of any diminution in the value of the lot because the tiles in the bathroom are mismatched. Accordingly, I reject a claim for damages on the basis of a diminution in value. There's a hint for all of us. There's a real hint there for all of us. If you are going to say, I want to claim damages from the owner's corporation because I got mismatched tiles, you got to prove your loss. You go, why is this a loss? Have you got a real estate agent in there to say, do you know what? If I was going to sell this place, I think it would sell for 10 grand less because this bathroom looks terrible. Would that be enough? Maybe you need a valuer. Maybe you need a valuer to do that. If you're going to complain about your loss of value and say that's my damages, you need expert evidence about that. Section 122, subsection 6 says the respondent will be liable for any damage to a lot or any of its content. I find the removal of an old tile and its replacement with a new tile of a different color, which doesn't match, is not actually damage to the lot. So on that basis, the applicant wasn't going to get up. It's not damage to the lot. I find damage in the context of section 122.6 relates to physical damage, breaking, disfiguring, harming some part of the lot. What the tribunal goes on to say is what you're talking about here, owner, is financial damage, financial loss. You've lost money, you've lost value. That's a different claim. It is a claim you can still make. You just have to make it under a different section, section 106, not section 122. That's kind of neither here nor there. And the tribunal does give a nod to section 102 and says, look, in any event, I don't find that you've suffered any damages that you could be compensated for because you just don't have the evidence. The only evidence of damage to the bathroom of lot 29 is the cracked tile, which has been referred to. So far as the mold is concerned, I find there's not adequate evidence to persuade me that lot 29 has become infected by mold because of the work carried out. So there might be photos of mold, but you've got to prove it's moldy because the owner's corporation didn't do the work properly. Okay, you've got to go that extra step. How do you do that? You need expert evidence. It was only hearsay evidence from the tenant saying the mold started after the work was done. That's not evidence that the tribunal was willing to give much weight to. The applicant did give evidence of the cracked tile. All right, so they had the photo, cracked tile, that's easy enough. We've got a cracked tile. But there was no evidence of the cost to make it good. The applicant has produced 2 quotes for work to the bathroom between 12 grand, 24 grand. Sounds like a new bathroom, right? But these quotes do not address the cost of repairing the cracked tile. I will not make a guesstimate of the cost to repair or replace the cracked tile when precise evidence could have, but was not provided. So was it possible to just repair the cracked tile and still make the bathroom watertight, waterproof? Maybe. I don't know. I think there's probably a good argument that no, that's not possible. Where you've got cracked tiles, you've got to pull everything out and put everything back in order to meet the current standard. I think that that's probably a good argument, but you need the expert evidence to make that argument for you. You need an expert to say that. There was an expert in this case, but it was an expert for the owner's corporation. And there was a bit of back and forth about whether the patch repairing was good enough. And the expert was cross-examined. And in the expert's report, he had said, yes, a patch repair is reasonable and functionally effective in preventing water ingress below. Based on my inspection and testing, this is fit for purpose. The small amount of work the owner's corporation has done is fit for purpose. But the applicant said that when the expert was cross-examined, he made an admission that there's no Australian standard for patch repair. So that submission was made by the lawyers at the end to say, yeah, but the expert changed his position under cross-examination. But the tribunal said, well, no extract from the recorded hearing was provided to substantiate the above submission. I'm not persuaded that Mr. Fisher, the owner's corporation's expert, said that. Tribunal couldn't remember him saying that. So in any event, tribunal said, I form the view that nothing really turns on this concession, even if it was made. because the applicant hasn't provided any alternative evidence, no alternative expert opinion. The fact that the respondent may have arranged for work to be carried out, which was in the nature of a patch repair and not in full compliance with the applicable Australian standard, does not of itself persuade me that there has been damage to Lot 29, particularly in circumstances where the only expert to give evidence in these proceedings said the patch repair was fine, could have long-term functionality. A lot owner is not entitled to require an owner's corporation to carry out work to common property as he, she, or it considers desirable to do so. So that's the tribunal saying you can't just say you want it. You can't just say, I think I need. You can't just say, I believe. You can't just say, it's obvious. Of course, you can't leave my bathroom like that. You have to provide expert evidence. If the methodology adopted by the respondent, the owner's corporation, falls short of providing an adequate outcome leading to a further breach of Section 106, the owner's corporation will continue to be liable for any further work. And as I keep adding to that, and I think if the methodology, if it's proven by the applicant that the methodology falls short, then the tribunal needs to make a decision about which methodology it prefers. And I've seen the tribunal do that in many, many cases and side with lot owners where the owner's corporation has said, no, we'll just seal it. If the lot owner can produce a good expert's report saying, no, that's not the way to do it, then the tribunal is going to find that the proper way to do it is to do it in accordance with the lot owner's expert advice. But you've got to have that expert advice on if you want the tribunal to make that decision for you. Okay, so I'm seeing Michelle's posting the Australian standard there in the chat. Thank you for that, Michelle. But here's the thing. You can't tell the tribunal that. You are not an expert and the tribunal is not an expert in the Australian standards. We might be able to identify that there is a standard. Does it apply in this case? I don't know. Is the damage sufficient to trigger the need to do the work and therefore we need to apply the standard? We don't know. We still need to go, even though this might be obvious, even though we might have done this 4 times already and we know the standard and we know what needs to be done, the tribunal is not going to take it as fact from you. They can only take it as fact from an expert. Okay, so ultimately in this case, application dismissed. Application completely dismissed, nothing awarded to this owner at all. They're still living, I imagine, perhaps with their mismatched tiles in the bathroom and their cracked tile. See, there's not even an order there for the owner's corporation to fix the cracked tile. In the event a party is minded to make an application for costs, make that application within 14 days. So here we are back to our costs. This is where the tribunal has said, well, one person's been successful, the other one hasn't. I see there's lawyers involved on both sides in this case. There may be a wish for one of the parties to, the successful party, to seek a cost order. I'm going to give an opportunity for submissions on costs to be made. Don't forget to ask for that. If you are successful and you've incurred some costs that you would like to claim, seek an opportunity to make that application. Okay, so lots happening in the comments. I know we're going to wrap up very shortly. However, Suzanne saying, wouldn't the tradesperson or company be responsible for the costs of shoddy work? Yeah, quite possibly. If the owner's corporation ended up having to pay damages because the applicant put their case really well and had expert evidence supporting them, and tribunal said, yeah, this is shoddy work, it needs to be done properly, owner's corporation could then go to the trades that it had paid and said, what? Hang on, why did you tell me that this was the right way to do it? Obviously, it's not. So yeah, but we didn't get that far. This owner unfortunately couldn't get that far. Patricia helpfully posting in there the NCAT procedural direction for expert witnesses. If you are engaging an expert to make a report for you, create a report for you that you're going to rely on in the tribunal, please do give that person a copy of that procedural direction for expert witnesses. It informs the expert of how they need to set out their report, what kind of things they need to say, and what their duty to the tribunal is. Good one. Thank you, Patricia. Leonie saying, can they now have expert evidence completed and appeal? No, they can't. And that's the sad thing. That's the sad thing. You just got one bite at this. You can't appeal because your grounds of appeal are that the tribunal got the law wrong. The tribunal didn't get the law wrong here at all. And you can't go and gather new evidence and put it before the appeal panel. You can't retry your case. That is not what appeals are for. Okay. Yeah, Patricia's shocked about the strata manager's advice to add those costs to the levy, to the levy ledger. Absolutely. All right, excellent. Now, I hope that case was as interesting for you as it has been for me now. That's the third time that I've gone through it. More things there jumping out to me. This is how we learn. As I say, this is how we learn, especially those of you who want to represent yourselves in your tribunal cases without the assistance of lawyers, without engaging a lawyer. Yes, without engaging a lawyer directly, please be reading the cases. Read the cases. Keep tuning in. I like to bring you cases here regularly. You tell me that that's what you enjoy, because this is what not to do. What not to do. It's great to read cases where lot owners who have been successful, getting their damages claims, getting their work orders, winning their case, getting their costs, just as, if not more, I think helpful to read these cases where owners have not been successful and to find out why, and to make sure that we, and I'm going to say we, because I act for owners in these cases as well. I have little notes now in the vault here. Oh, yeah, better make sure we do that. This issue about how do you prove your damages if you've got the mismatched tiles? You got to get some valuation advice saying my property is now worth less than it was before because I've got mismatched tiles. Great point. That is a great point. Good reminder for all of us. That's all I have for you today for our Friday Live. Thank you for being here. Thank you for sharing your comments so generously, tuning in, learning more about Strata. I plan to be back here in a couple of weeks' time. Have a fantastic weekend. I often encourage you to get out of Strata on the weekend if you can. I try to do that, try and get away from Strata, whether that's just taking a walk in nature outside of your building. Please do put that on the list for this weekend. I'll catch you all sometime, somewhere, probably here next time. Bye for now.